Hi, welcome to our podcast, Legalize Negligence. This is where we discuss Chapter 768.21, subsection 8 of the Florida statutes, which deal with who can recover damages in a malpractice case. I'm joined today by my buddy Travis, who helped me get all this off the ground. We've kind of done this as a collaboration between the two of us. We've been working together for about a year now, trying to come up with other ideas to help the legislature in Florida solve this alleged medical crisis that's been going on for 33 years. And also, I call her Sabrina Boots on the Ground Davis. She is the one who is very well known in Florida at the state legislature and numerous television stations for telling the story about her dad and how she got involved in this. Travis, would you like to say something since this is the first time you've had an opportunity to join us?
Sure. Thank you, Philip. I've been after this calls for 4 years now. Just had the 4-year anniversary of my mom's death. Lost her eyesight to medical malpractice. Still have to prove that. Lost my dad to admitted medical malpractice, and didn't find out about this law till I lost my mom because she was a widow at the time, and just couldn't believe it. Totally unconscionable that this just creeps up on you and it's too late. So we're here to try to let people know about it before it catches them off guard. And welcome.
Sabrina, if you want to, our topic today is going to be talking points for when you go to a delegation meeting. And if you want to mention how this came up for us to decide to do a podcast on it, please do.
Sure. So thanks for having me today. And I've been receiving a lot of messages via Facebook, email, text message on what to say to legislators, whether it be in person at delegation meetings, or what to say to their local House reps and senators via email. And it's a very common question. So I think it's a great topic for us to discuss today. That way we can kind of answer everybody's question at once, and hopefully help paint a better understanding, because it can be challenging when you're approaching a legislator and you don't know what to say. But hopefully this answers a lot of questions.
I think this is a great topic because I got involved in this stuff. Well, my mom died a little over 3 years ago, but I actually started getting involved in this activism about 2 years ago. And what I noticed was that the people who went to these delegation meetings across the state pretty much just told the story of what happened to their loved one. And like with any, oh, this would be a real good place to mention. Nobody here on the screen is a lawyer. We're just regular people who saw an injustice happen and we're trying to right that wrong. So nothing we say is legal advice. Anything we say, we ask you to do your own research and back it up and see if what we're talking about is correct. And if you think we're wrong, then please let us know. In any court case that's filed, there is something, and it's called, they refer to it differently in different states, but basically it's called your prayer for relief, what you're asking the court to do. Everything that you do in a lawsuit, you're moving the court towards something. So your prayer for relief would be, Your Honor, I've presented my facts here. You can read them in my pleadings, and this is what I want the court to do. So I thought, well, wouldn't the same apply if you're talking at a delegation meeting? You're going up and telling the legislators, a lot of them know what subsection 8 is all about, but some of them don't. So you're telling them what happened, you're telling them what the law does, but now you've got to tell them the relief that you're looking for. And that is the redress part of petitioning your government for a redress of grievances. You want a resolution to your grievance, so you've got to give them that resolution. So when Sabrina told me about a lady that contacted her last week and said that she wanted to go to a meeting, but she really didn't know what to say, I jotted down. Of course, there's a million things that we could say to them, but I kept it to 6. And I'm going to go ahead and share that screen right now. Nobody's going to be able to read this. Well, you might be able to read it off the screen. Let me get it shared. But if you will write to me, anybody watching this video, if you'll write to me at Philip with 1L at legalizednegligence.com, I'll be happy to email you this. And basically what it is the bolded portions, the bolded headings tell you what's in the paragraph. And if you'll read the paragraph, you'll understand what the talking point is all about. In some of it, I go into a little bit of history, and some of it I go into how to come up with a counter argument. But it's a little 3-page thing I wrote this morning, and it'll help people understand, how to form your resolution that you want to say to your legislator. So I start off with just a little brief thing talking about how the legislation came to be and who it affects. And then at the bottom of that, excuse me, I say, according to the doctors and the insurance lobby, med mal premiums in Florida are still the highest in the country. If this is true, then clearly the law has not met its intended goal. Maybe it's time for the legislature to look at a different approach. So how do you know what to say? Well, to me, it was easy. Listen to what the opposition is arguing. And I did that by listening to a couple of the lobbyists when they were recorded at these delegation meetings. I just listened to what their arguments were, did my own research into their arguments, and came up with counter arguments. So if you want to figure out what you want to say, listen to what the other side is saying. Don't listen to them with a goal towards responding. Listen to them to understand their argument. And once you understand their position, then it helps you form your position and hopefully persuade them to do something differently. On the next point here, the first question to ask, in my opinion, the first question to ask is whether or not the crisis still exists. There were 2 court cases, and I cite them in here. Calatan versus North Broward Hospital, and then the famous Mizrahi versus North Miami Medical Center, where justices on the court, and both of them were Supreme Court cases, justices on the court questioned whether or not the crisis still existed. It's now been 33 years. Maybe the legislature needs to take a step back. Maybe they need to form another task force like they did in the 1980s and look at if the crisis still exists. Does Florida have enough doctors to cover its citizens' needs? What are the medical malpractice rates in Florida compared to the malpractice rates in other states? And you can't just go by what the rate itself is. You have to look at the cost of living in different states. You can't say that what a doctor pays for a home in Miami is going to be equivalent to what he pays for a home, somewhere in North Dakota. There's a lot of things that go into that equation. My next talking point, and y'all stop me if you have any questions along the way here, okay? I don't want to dominate this conversation or this presentation. The next one that I have here, number 3, is no one is addressing the actual malpractice that takes place when subsection 8 applies. And what I mean by that is when you listen to the lobbyists at these delegation meetings, they will talk about how necessary it is to prevent lawsuits from clogging up the courts. And that's why the legislature wrote into law subsection 8. But they ignore the fact that medical malpractice just occurred. Somebody died because medical malpractice occurred. What they will do if you confront them with that head on, what they will do is say, well, the legislature left you a remedy. All you have to do is file a complaint with the Department of Health, and you can hold the doctor accountable. Well, the majority of us say that that's not true. In rare exception, will you find a case like with Sabrina's dad, where she made it all the way to the end of that process. But at the end of that process, the doctor who whose negligence led to her dad's death was fined $7,500, and he went back to work. And but those cases don't happen very often. Usually the case gets shut down before it ever gets before a board of medicine or a board of nursing. And that generally happens because the average person does not know how to navigate the waters of the administrative courts, the administrative agencies. They won't tell you anything. You're left on your own to figure out what to do. They won't answer your questions. If they decide to close your case, they'll never tell you why. The records are sealed. Nobody, the public can't review those records like they can in other cases. And the worst part, the doctor or the nurse goes back to work and is never affected by Florida's three strikes law. And I'd like for you, Travis, if you will, for a moment, talk a little bit about Florida's three strikes law.
Well, Florida will take away the right of a medical licensee to practice in Florida if they have been found at fault through the Department of Health 3 times, or through civil action 3 times, or a combination thereof. But often they will just settle out of court, and settling prevents the finding of fault necessary to get a strike. So while I see that the estates need to settle in order to take care of the estate, it really gives a pass on the medical licensee, and puts everybody else at risk.
So if I'm understanding you correctly, your loved one dies, you're the representative of the estate, and you're up against the clock because you got to get everything settled. And the doctor and the negligent doctor and his attorney understand that. So they drag this thing out to where you can't, you're feeling the pressure to settle with them so that you can get the estate closed out, because the probate courts are on your backside now. They want you to get your job done. So they just kind of wait you out until you get to a point that you say, okay, I'll take your settlement offer. And then they know that the doctor never has to get a strike against him.
Right, but even the state, the law encourages the settlement that prevents the inaction or the action of the law. In other words, if they offer you a settlement and you choose not to take it, but you win in court less than 25% over the amount that they offered, you have to cover their attorney fees. So it kind of forces you to, it creates an atmosphere of accurate settlement claims, I would think. But if one side is just thinking, hey, I'm going to lowball them, or the other is thinking, I'm going to highball them, then the law is there kind of forcing you to take the settlement for fear of having to pay the attorney fees. And that negates the whole purpose of the strike.
I guess the important thing to point out here is if we could get into civil court like every other tort claim in the state, that wouldn't be an issue for us.
Correct.
Okay, I thought so. All right, I'm going to move on to the next talking point here, the 1988 task force recommendations. Now, this is an interesting study. In the mid 1980s, I still haven't been able to find out who it was that brought it to the legislature's attention, but somebody was crying that there's a medical crisis in the state of Florida, and that doctors are leaving the state in droves because their malpractice premiums are too high. So in 1987, the legislature created a task force to study the issue. And in 1988, the task force, even though it was not tasked with giving recommendations, it decided to give recommendations. And the lobbyists for the insurance companies and the doctors groups and the hospital groups, the lobbyists are hanging their hats on what this task force had to say. But after reading nearly 600 pages, there were actually two papers that came out. There was the first one was just kind of like a preview of what was to come, and then the second one came out, and then there was a law review article that was written, and I referenced that in here about this whole thing. And there were things that the task force actually recommended against doing. In fact, I'll read the language here. It says, however, the lobbyists don't like to talk about the fact that the task force recommended against, and I put this in quotes, adoption of reforms that limit a plaintiff's right to recover damages while requiring the plaintiff to prove fault. Well, I mean, that's exactly what subsection 8 did. And the task force said, no, we don't recommend that you do that. Another thing that the lobbyists don't like to talk about was on the November 1988 ballot. It was an election year in Florida. There was Amendment 10 was added to that ballot for the voters of Florida to decide whether or not they wanted to allow a cap on non-economic damages in tort cases of $100,000, and it was rejected by the voters. The voters said, absolutely not. We do not want damages capped. And to me, that's the same as a jury speaking. The people have spoken. They've instructed their legislators that they don't want them capped. And what did the legislature do? The exact opposite. But you'll never hear the lobbyists talk about this stuff. They don't expect people to sit down and read these things. I know Travis and I did, because we're kind of weird that way. But when you read it, you find out that, sometimes what these attorneys are saying, they're doing it to create a narrative and to make the legislators think, because they know a legislator has so much on their plate, they're not going to sit there and read a 600-page document, or actually 3 documents at total, almost 600 pages. So that's the other thing that people could bring up at a delegation meeting, is whether or not their legislators have actually read this task force report from 1988, because that's what the whole law hangs on. If they'll take this thing, and if the legislator wants to write to me, I'll be happy to send him a copy of it and look at what it says and see if that aligns with what the 1990 legislature eventually did. In my view, it doesn't. It went completely against it. The next talking point I have here, I'm trying to go a little fast because I know people's time is short, and I know they're not going to watch a really long video. The history of medical malpractice and the recovery of damages. This is another thing that people need to learn about. There's one particular lobbyist named Mark Delegal. He's an attorney who represents several insurance companies, and Mark's a nice guy. He's friendly, he's cordial, and he's a smart guy. But he brought up the fact that that there was a time in our history when no one was allowed to recover damages in a tort case. Well, okay, that's fine. But there was also a time in our history where women couldn't vote and blacks had to ride in the back of the bus. And if you go back far enough in our history, blacks were not allowed to be educated in schools. There were a lot of things that used to happen, but our society evolved, and our society changed its views. And the people of America looked back on the mistakes of the past and said, we don't want it like that anymore. We want to change. And my view is that's what happened with damages in torts. The people said, wait a minute, we want to change. and we're going to elect people who are going to make that change. And the legislature created the ability for people to be able to recover damages whenever malpractice occurred. So if Mark wants to take us back in time to, to a point when you couldn't recover damages, then maybe we should go back in time where his wife can't vote, or where his black neighbor has to ride in the back of a bus, or can't go into the same restaurant as he does. I just don't think that that's a very strong argument to say at one point in our history. But there's some more things there that I have that someone could read, and once they understand the argument, they can come up with other ideas on why the legislature eventually allowed people to recover damages. Basically the people spoke. They said that's what we want, and the legislature put it into law. And then the last point that I have here is subsection 8 created the unintended consequence of unjustly enriching the insurance companies. And I give a brief description of how that happens. And I don't know that all the legislators actually think about that. And I use the example of, we have to have insurance to drive our cars on the street. And the insurance company is taking the gamble that we won't get into auto accidents. And if you never get into an auto accident, you've paid years and years and years of premiums. And that's how the insurance company makes its profits. Well, that's exactly the same way that it works with malpractice insurance. And subsection 8 is allowing the insurance companies to be enriched by the fact that the doctors can't be sued in these cases where subsection 8 applies. Are there any other, that's basically what I have for this. I'll send this on to you guys once I edit it and, proof it and make sure all the spelling's correct and all that. And anybody who would like a copy of this, I'll be happy to send it to them as well. Are there any other ideas that you guys have that people could speak to their legislators during these delegation meetings?
I would say try to offer solutions based in law. It's one thing to get up there and tell a story, but if you can't offer a solution, then it doesn't help much. And prime example is Senator Danny Burgess. He was interviewed by a reporter, and they asked him, like, why can't we do this? And he basically said that would just absolutely, possibly open up a Pandora's box. It's a definite maybe. Not true to happen, not guaranteed to happen, but because it might happen, but he's had years to come up with his own solution. He's in a seat of authority to do something, and yet he's offered no solution whatsoever.
Travis,
avoiding it.
That's a perfect example of when I say that they're not addressing the fact that malpractice occurred. Senator Burgess's response was because it would just open up a Pandora's box of lawsuits across the state. Well, maybe those lawsuits need to happen. Maybe if we could get rid of the doctors who are committing that malpractice, maybe there wouldn't be as many lawsuits. You and I both discovered in some of these cases that we've read, actually, it was a task force study that we read, 4% of the doctors commit 42% of the malpractice pay. They cause 42% of the malpractice payouts. And it's like, well, if you get rid of 4 bad police officers to save 100 good ones, that seems like something that would benefit the public. And maybe there wouldn't be so many allegations against bad police officers.
Valid point.
How about you, Sabrina? Is there anything? I know a lot of people contact you who are both in our position and, news reporters contact you. Is there anything that you can think of mention here?
Yeah, I think when speaking at a delegation meeting, it's important to bring a handout to leave behind, because there's just really not a way to say all of that in the 1 to 3 minutes they give you. And something else to think about is who you're speaking to. I know I said this last time, but you're not only educating or bringing to light this issue to the legislators in front of you, but the massive crowd of people behind you, the constituents, are also listening. I've been approached in the bathroom at a delegation meeting in Duval County by someone who said they couldn't believe they heard me speak because the same thing happened to their significant other's mom. And you just don't ever know who you're talking in front of, um, or who you might educate, or who falls into this category and they didn't know, or who has had this happen to them and they just didn't know that there was a group of people fighting to change and end this law. So you can't go wrong by speaking up, and just having the handout for them, it's always helpful. And to be honest, they've heard stories from so many people, and our stories are not going to be what changes this. Like Travis said, we have to present a solution, otherwise we're just another story. And I've been there. My speeches sometimes are just another story, but when I speak on how we can fix this and how terribly wrong it is, that what's really happening is so much more than sad stories, that's where you get the feedback that we actually have a chance at this. So I'm looking forward to the upcoming delegation meetings, and the new approach, and I hope that this can help many other people as well.
Cool. Cool. Travis, you have anything else you'd like to add?
I would say like, subscribe, check the bell so you get notifications, come back and learn some more.
Yeah, I would have to agree with that. The more people that we can get to start understanding that it's what we say that's going to make a difference. As Sabrina just pointed out, if our story about what happened to our loved one was going to make a difference, it would have done so long ago. You know, these are horrific things that happened, and if emotion alone was enough to change law, that would have happened. What we're trying to do at Legalized Negligence is give the legislature other ideas to approach this and make a change, and let them understand that we're starting to recognize that what they have been doing has not worked for more than 3 decades. It's not worked, and maybe it's time they listen to us. Article 1 Section 5 of the Florida Constitution says that we the people have a right to instruct our legislators, and that doesn't mean screaming at them. It means sitting down and talking to them and presenting our side, and hopefully they'll be open enough to listen to it. Well, I appreciate you guys joining me today. Like Travis said, like, subscribe, ring the bell, all those other kind of things. Tell your friends about us. You can find our YouTube channel at legalizednegligence.com, and let me put up our Facebook page so that you can join us there as well. Did that show up yet, Sabrina?
Not yet. There it is.
Okay, Legalized Negligence, the state of Florida versus the people. And we have some videos on here, and Sabrina posts things that helps people find out how to know who your legislators are, and how to attend these meetings, and just any news articles that we have and so forth. But we appreciate your time. We know it's very valuable, and we hope to be putting these podcasts out at least a couple of times a week, even if they're just a little 5-minute thought at some time. But everybody, enjoy your weekend.
Thank you. Bye.
Thank you.